5 seconds to go. Start. This appeal is preferred against the order dated 19 December 2014, whereunder the learned single judge allowed WP Civil number 1842 of 2012, filed by the respondent herein, and set aside the order dated 1st February 2012, passed by the Central Information Commissioner CIC under the Right to Information Act 2005, for short RTI Act. The facts in brief are as under. The appellant herein filed an application under the RTI Act with the Central Public Information Officer, Department of Justice, Government of India, seeking the information relating to the details of the medical facilities availed by the individual judges and their family member of the Supreme Court in the last 3 years, including the information relating to expenses on private treatment in India or abroad. The CPIO to whom said application was transferred under Section 6(3) of the Act rejected the same by order dated 2nd February 2011 on the ground that it is an exempted information under Section 8(1)(j) of the Act. The appeal preferred by the appellant herein was dismissed by the First Appellate Authority by order dated 7th March 2011. However, the further appeal to the CIC was allowed, and by order dated 3rd August 2011, the CIC directed the CPIO to provide the total amount of medical expenses of individual judges reimbursed by the Supreme Court during the last 3 years, both in India and abroad, wherever applicable. There was also a direction that the CPIO shall bring to the notice of the competent authority in the Supreme Court and ensure that arrangements are made in future for maintaining the information as while furnishing the actual total medical expenditure for the years 2007-8, 2008-9 and 2009-10, informed the appellant herein that the judge-wise information regarding actual total medical expenditure is not required to be maintained and is not maintained, contending that the information furnished by CPIO is not in compliance with the order dated 3rd August 2011. The appellant herein had again approached the CIC, and thereupon by order dated 1st February 2012, the CIC reiterated its directions dated 3rd August 2011. Aggrieved by the said order, the appellant herein filed WP Civil number 1842 of 2012. By the order under appeal, the learned single judge allowed the writ petition, holding that the order passed by CIC purportedly in exercise of power under Section 19(8)(a)(4) of the Act is erroneous. While taking note of the fact that the information sought by the respondent appellant herein was with regard to expense incurred on medical facilities of judge retired as well as serving, and that the said information is personal information which is exempted from disclosure under Section 8(1)(j) of the RTI Act, and that the medical bills would indicate the treatment and or medicines required by individuals, and the same would clarify be an invasion of the privacy, the learned single judge held that the question of issuing any directions under Section 19(8)(a)(4) of the Act to facilitate access to such information does not arise. Assailing the said order, Shri Prashant Bhushan, the learned counsel, appearing for the appellant, vehemently contended that the information pertaining to expenditure of public money on a public servant is not exempted under section 81J of the RTI Act. Stop.